In the UK construction industry, sensitive information is often exchanged between parties, such as contractors, clients, consultants, and suppliers. To protect this information, legal agreements are often put in place, most commonly non-disclosure agreements or confidentiality agreements. While these terms are sometimes used interchangeably, they can differ slightly in scope and purpose, depending on the context and the specific wording. Let's start with NDAs. A non-disclosure agreement is a legally binding contract that prevents one or more parties from disclosing certain confidential information shared during a business relationship. In construction, NDAs are frequently used during early project stages. For example, when a developer shares site plans, commercial proposals, or proprietary designs with a contractor or consultant before a formal contract is in place. An NDA sets out what information is considered confidential, who is bound by the agreement, how long confidentiality must be maintained, and the permitted use of the information. NDAs can be unilateral, one party is disclosing information, bilateral, both parties are sharing confidential data, or multilateral, more than two parties involved. In construction, bilateral NDAs are common when two firms explore a joint venture or collaborative bid. So what is a confidentiality agreement? A confidentiality agreement serves a similar function to an NDA in that it restricts the sharing of confidential information. In fact, in many cases, the two are functionally the same. The difference lies more in terminology and emphasis. A confidentiality agreement tends to be a broader, more informal term and may appear as a clause within a wider contract, such as a consultancy agreement, pre-construction services agreement, or design and build contract. For instance, a quantity surveyor's professional appointment may include a confidentiality clause stipulating that they must not disclose any client information to third parties, except as required for the delivery of services. While there is no strict legal distinction between NDAs and confidentiality agreements in UK law, the practical context can often differ. Standalone versus embedded. NDAs are typically standalone documents, often used at a pre-contract or tender stage. Confidentiality agreements are more often than not embedded within larger contracts. Formality. NDAs are usually more formal, with clearly defined legal consequences for breaches. Confidentiality agreements may be light to touch, especially where ongoing working relationships and trust are key. In the UK construction industry, the term NDA is often used in situations where commercial sensitivity is high, such as mergers, acquisitions, or design innovation. Confidentiality agreement may be used more casually or internally within project teams. In summary, both NDAs and confidentiality agreements aim to protect sensitive information, which is crucial in a competitive and high-value industry like construction. While the terms are often used interchangeably, understanding their context, particularly whether they are standalone or part of a wider contract, helps clarify their purpose. For construction professionals, ensuring these agreements are clearly drafted, appropriate to the stage of the project, and legally enforceable is essential for maintaining trust and safeguarding commercial interests. Metroun, a commercial hub for your business.